everyone. Hello. Didn't expect to do a live stream today, but when do I expect to do a live stream? Never. They're very impromptu these days because, things just happen. Things just happen all around me. So this afternoon, it's currently 5 o'clock my time. This afternoon, I've had a very interesting afternoon listening to the evidentiary hearing where Alec Murdoch is trying to get a retrial. And Judge Jean Toll, in that case, is a very nice judge. She's taken over from Judge Newman. She's very nice, and she's taking no nonsense. And she's had each of the jurors in, one after another, to ask them questions about what the clerk of court, Becky Hill, supposedly said to them. And before I tuned into that, I did see the docket. I saw a screenshot of the docket saying that in the Delphi case, there was a motion to disqualify. So I thought, I'll come to that later. But now they're at lunch. They've gone to lunch in the evidentiary hearing in South Carolina. And I can concentrate on this. So I've got all the PDFs. And there isn't just one motion. No, there are several. So we've got quite a lot to go through. More to go through than I anticipated. So we better just get started, I guess. We've got a lot. So fur is definitely flying over there in Indiana. Left that address, Michael Vaughan, in the last video. What address? I don't know what address you mean. Yeah, well, I haven't read them. I haven't read any of the documents. So you'll be getting what I think, for just my raw thoughts. Yeah, it's normally fur flying in my house, but yeah, maybe with Judge Gull, maybe it is feathers. Maybe it is. Hello, Spanish Angel. CW. Bonjour. Jesse. Or Jesso. Jessa. I so need to get my eyes tested. I can't read. Owen Flo. Sweet Peas. Thunderhorse. Sandra. Neela. Not enough. Kai Mojo. Is it? Yeah, Kai Mojo. A bunch of people coming in. All right. Snark alert. I don't know how snarky I need to be yet because I haven't read any of them. All right, so this is only a short one. We'll do this one first. This is only 3 pages. The motion to disqualify is going to take a while. Okay, let me put my screen share on here. Okay, so this is the state's motion to compel discovery. So the state are asking for discovery from the defense. It's interesting. Because not only are the defense entitled to all of the discovery from the state is also allowed to get discovery from the defense as well. So here we go. State of Indiana, by its prosecuting attorney, Slick Nicholas Charles McClelland, respectfully requests the court order the defense to comply with Indiana Supreme Court rules of criminal procedure. So Slicky Nicky is saying that they're not complying with rules. Oh no, Denise, your son's been in hospital with double pneumonia. I hope he's getting better. What time is the Paul Ferguson sentencing? I don't know. I didn't even know he was being sentenced today. I watched the Shanda Van der Ark sentencing. I didn't know Paul was being sentenced today, so I don't know. Someone in chat might know. I'll go and watch that later. Delphi docs are quite lengthy. Don't think Judge Gull will step down without a fight, although she needs to bow out. Yeah, I'm doing this short one first, and then we'll get to the longer ones, because there's a whole affidavit to read from Richard Allen. So I'll skip through this pretty quickly so we can get on to the interesting stuff. So court granted a motion by defence for discovery deadline on November the 1st, and the state complied with that order. So the state have given over all of their defence. Because if you remember, if you go back, cast your mind, we're all the way back to last year, that the discovery deadline was the 1st of November for all of that to be turned over ahead of a January 8th start date. That didn't happen. Therefore, hey. Oh, he's being sentenced. The sentencing is in February for Paul Ferguson. Oh, all right. Okay. So, Carroll County Local Court rules direct all discovery is to be exchanged between state and defence automatically and continuously. That, effective January 1st, 2024, the Indiana Supreme Court issued rules of criminal procedure wherein Rule 2.5 states that parties must endeavour to share information without court involvement. Blah, 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 blah. Okay. Subsection C, disclosure by the defence, states that within 30 days after the prosecutor's disclosure, the defence must furnish the state with the following material and information within the defence's possession or control: the names and last known addresses of persons whom the defence intends to call as witnesses. So they had 30 days. So why is this coming to court? Why is this a motion to come to court? Why is this? Because it's saying here, subsection C states that within 30 days after the prosecutor's disclosure, the defence must furnish the state with the following, and a bunch of stuff. Well, if you remember, cast your mind back on October the 12th, Judge Francis Gull told attorneys Baldwin and Rosie to quit working on Richard Allen's case. So if the state turned over all of its discovery in time for the November 1st deadline, well, Baldwin and Rosie have only been back on the case for a few days, not 30 days. So where's he counting his 30 days? Is he counting his 30 days from the date he turned things over, like all of the stuff went over? Because if that was within 30 days of them being quote unquote disqualified by Judge Francis Gull, they've not had the 30 days yet, have they? They haven't, have they? So I'm already snarky. I'm already getting annoyed. Okay, so witnesses, yeah. Okay. Defence may refrain from providing witnesses' address or other contact information under this rule if the defence, in good faith, believes the disclosure of the witness's address may jeopardise their safety. Okay. Any books, papers, documents, photographs, or tangible objects that they intend to use as evidence, any reports or statements of experts made in connection with a particular case, including results of physical or mental examinations and of scientific tests and experiments. Well, the judge already ruled that the state wasn't allowed to have a mental health report from Richard Allen. Okay. All right. But that might be used in trial. All right. The defence must disclose any statutory defence in writing by the statutory deadline, or if there's no statutory deadline, within reasonable time. That to date, the defence has neither turned over any discovery, nor have they provided the state with a list of expert witnesses that they intend to call at trial or any pre-trial hearing. That despite requests by the state of defence, blah, blah, blah. Right, so it's nonsense. All right. So I'm sure they'll turn over everything. I'm sure they will. However, that's not our main priority right now, because Judge Francis Gull basically reset the clock in telling Baldwin and Rosie to quit working on the case. She stopped the clock. Simple as that. So she needs to, why that's come to court right now, I do not know. All right, let's get to the interesting bit. Let's get to the disqualification. Motion to disqualify. So the accused, Richard M. Allen, by attorneys Bradley Rosie and Andrew Baldwin, pursuant to Rule 2.4 of the Indiana Rules of Criminal Procedure and Rule 211 of the Indiana Code of Judicial Conduct, respectfully moves for a change of judge from Judge Francis C. Gull or a recusal from this cause. In support of said motion, Richard M. Allen swears and affirms the following. If you remember, there is a gull emoji now. Just telling you. There's also a wheat emoji that you might like to use in chat. Okay. The filing of a motion for disqualification and or request for recusal strips the court of jurisdiction to decide on any matters until a ruling on the disqualification motion occurs. So basically, she's got to quit working on the case. She has no jurisdiction over this cause. Now this motion's in, and she can't get rid of. There we go. There we've got some gull emojis and wheat emojis coming in. Until this is settled, she is no longer jurisdiction over this case, according to these sightings here. So what it essentially means, so what I think, because I've been waiting every day for Bradley Rosie and Andrew Baldwin to file their 70 days. Yeah, I think they should have. Kai Mojo, I think the Supreme Court should have dismissed her. However, maybe they thought that set somewhat of a dangerous precedent. Gypsy Girl, member for 1 month. Thank you so much. Yeah, Mike, can see you. And what excuse will she come up with this time? Because last time they issued a motion to disqualify, she just removed it from the docket because she said they weren't attorneys anymore. But yeah, so the state, so this is Rule of Procedure 2.4b. The state or defendant may request a change of venue from the judge only for bias or prejudice. The motion must be accompanied by an affidavit signed by the defendant or prosecuting attorney. So in this instance, it's the defense who are asking for a disqualification of the judge. Therefore, it will be signed by Richard Allen, and we've got that. It's an affidavit. We're going to read that next. The affidavit must set forth facts and reasons for the belief that bias or prejudice exists. If the defendant signs the affidavit, the defendant's attorney must file a certification that the attorneys believe in good faith the facts recited in the affidavit are true, and they've done that. The court must grant the request if the facts recited in the affidavit support a rational inference of bias or prejudice. So she's going to come along and say, there's no bias, therefore I don't need to recuse myself. Yeah, that's what she's going to do. Put another way, the facts contained in the affidavit must show there is reasonable basis to question the judge's impartiality towards Richard Allen and his defence team. Okay, so Rule 211 of the Indiana Code of... I was halfway through a thought before. Sorry, I'm all over the place today. I was halfway through a thought. I was saying every day I've been expecting them to put in the 70-day heads up that they want a trial within 70 days. And they haven't done that. So it's been on my mind as to, are they going to file a DQ first and get Judge Gull out first? Because if they file that speedy trial within 70 days and then they file a motion to disqualify the judge, then that's 70 days. The clock stops on that anyway, because there's no one, essentially the judge, until this is sorted. So they'll do this first, and then they'll file the 70 days. I'm guessing that that's what they'll do. So Rule 211 of the Indiana Code of Judicial Conduct requires a judge to disqualify him or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action. The rule on disqualification and the canon on recusal both adopt a threshold of reasonableness, i.e., would an objective person have a reasonable basis doubting the judge's impartiality? And I think there is. I think there's definitely reasonable grounds to infer that she has been biased, certainly towards Rosie and Baldwin. Just by her behaviour, she has. Okay. So, provides additional guidance. Under this rule, the judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply, whatever they are. In many jurisdictions, the term recusal is used interchangeably with disqualification. A judge's obligation is not to hear or decide matters in which disqualification is required. Applies regardless of whether a motion to disqualify is filed. Okay. A judge must disclose on the record information that the judge believes the parties or the lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there's no basis. So this is just the law on this. So the accused has a federal due process right to an unbiased judge. Of course they do. Under the 5th and 14th Amendment, judicial bias is one of the narrow classes of constitutional violations that implicate structural error. Cases of judicial bias involve a denial of the most fundamental constituents of due process, so fundamental that a conviction in the absence is indecent, even if the defendant is plainly guilty. Structural errors render a criminal trial fundamentally unfair and not subject to harmless error analysis. So the Supreme Court said, and we haven't got their full opinion yet in writing, but at the Supreme Court hearing back on the 18th, they were talking about Judge Gull committing a structural error in disqualifying Brad Rosie and Andrew Baldwin, right, with no hearing and no grounds, basically, no grounds to do it, because Richard Allen wanted to keep those attorneys. So that was a structural error. They're arguing here that the judge not recusing herself in this instance is also a structural error because she's biased. So if she doesn't recuse herself and Richard Allen is found guilty at a trial, he has grounds to appeal based on the fact that there is this belief that she is biased. So, yeah. So there's no recognizable legal, and there's no reason why she needs to stay on this case. Like, what is she? Is she just doing it to be? She thinks she's a badass, or what? I don't know. Why is she hanging on to this case so heartily? What is it? What is it going on with her? Here, there's no recognisable legal rationale which supports Judge Gull continuing to preside over this case. At every stage from now until the conclusion of this case, the actions and rulings of the court will be scrutinised through the lens of Judge Gull's error in severing Richard Allen's attorney-client relationship with his chosen lawyers. It will indeed. Will indeed. The preamble to the Code of Judicial Conduct provides that judges should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. Absolutely. And I don't know who believes, based on what happened at the Supreme Court, is there anybody out there who thinks that she's unbiased in this case? It doesn't matter how good she's been in previous cases, how good her track record is. I don't care about that. In this case, has she behaved in an impartial manner? And I can't see anybody would say yes to that. In fact, I'm going to do a poll. Let's do a poll. All right. Do you believe that Judge Gull is unbiased in the Delphi case? So, do you believe that Judge Gull is unbiased in the Delphi case? So, you're going to say yes if you think she's unbiased and no if you think she's biased. Start poll. All right, let's keep that running. Let's keep that running for a minute. Well, more than a minute. Vote in the poll. Vote in the poll. Okay. And it's an anonymous poll, so we'll keep that running. We'll look at that later. All right. So there can be no dispute that this has occurred. The highest court in the state of Indiana has cemented this fact. If the Indiana Supreme Court concluded that Judge Gull wrongfully denied Richard Allen of the attorneys of his choosing, wouldn't then an objective person have a reasonable belief that she, Judge Frances C. Gull, is biased and prejudiced towards defendant Allen? Judge Gull should recuse herself and in doing so restore any sense of impropriety that is clouding the system of jurisprudence in the state of Indiana and in this very proceeding because of the judge's prior actions. Recusal of Judge Gull will be entirely consistent with the spirit and foundation of Canon 1 and Canon 2 of the Code of Judicial Conduct, both of which are founded in the concept of judicial impartiality and fairness. Judge Gull continuing to preside over this case necessitates the following questions to be asked. Will Judge Gull's continued involvement create built-in reversible error in the event defendant Allen is convicted of any one of or more of the charged crimes? Will all future rulings of the court be viewed by the defence as being tainted with bias, prejudice, and lack of impartiality? Will the public be able to maintain any sense of confidence in the presiding officer, Judge Gull, is unbiased and impartial? Can Judge Gull process any information and or legal arguments offered up by attorneys Rosie and Baldwin, knowing that she has already made an extrajudicial finding that both attorneys have demonstrated gross negligence and gross incompetence in their representation of defendant Allen? Does Judge Gull have some ulterior reason or motivation driving her unwillingness to recuse herself from this case? Exactly. It begs the question, why does it matter to her so much? What is it? Why does it matter to her so much? Do the practical benefits of recusal far outweigh the inherent risks of Judge Gull remaining on the case especially as it relates to the likelihood of protracted and expensive litigation throughout the remainder of this case and in the appellant courts if conviction occurs. Accompanying this motion is the affidavit of Richard Allen setting forth facts and reasons why defendant Allen believes that a rational basis for questioning the judge's impartiality exists. The same affidavit set forth the facts establishing the timeliness of defendant Allen's request for a change of judge. And finally, this motion is also accompanied with a certification that Richard Allen's attorneys believe in good faith the facts recited in this affidavit are true and accurate. Signed, Richard M. Allen. Okay. Now for the affidavit. This is a long one. Okay. Let's just load this in here. There we go. Share that one. Okay, so this is 22 pages. Might need to go and get a drink in a minute. Not much Pepsi Max left in this can. Okay. Richard Allen swears and affirms that the following statements and reasons for disqualification are true and accurate. And I have either personal knowledge or have learnt of these facts and reasons through my counsel, Bradley Rosie and Andrew Baldwin. So this is written like as if Richard Allen was speaking. I'm sure he's not typed this up, but it's his affidavit. So he will have signed this, that he, you know, these are his words. He agrees with these words. 1. Judge Gull interfered with Richard Allen's attorney-client relationship. On October 12, 2023, Judge Gull instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely, effective representation guaranteed to him by the state and federal constitutions. This disarming of counsel also occurred immediately in advance of Judge Gull ordering up a hearing in her own courtroom in Allen County, Indiana. That was the 19th. At the hearing, Judge Gull staged a premeditated removal of attorneys Rosie and Baldwin, complete with cameras in the courtroom for the first time ever in this case, with Judge Gull having prepared in advance a handwritten statement with claims of grossly negligent and grossly incompetent actions on part of each lawyer. This directed by Judge Gull was included in an email dated October 12th. Okay. So we've seen those emails. 2. Judge Gull publicly and on the record disparaged defendant Allen's chosen attorneys. The whole world is definitely watching. We can pop that on the screen. The world sees what's going on. The world absolutely sees what's going on. Okay. All right. The week before the October 19th, 2023 hearing, Rosie and Baldwin had asked Judge Gull what to expect of said hearing. And we've seen these emails. We've seen these emails. All right. Rosie absolutely asked what the hearing was about. Sasha, member for 22 months. Yeah, you made it. You did. You made it. All right. Rosie and Baldwin knew from an October 10th, 2023 phone call that Judge Gull had commented that she was inclined to have Rosie and Baldwin removed from the case at the request of Slicky Nicky, her new best friend, prosecutor McClelland, before any hearing had taken place, before researching the issue, or even having any meaningful chance to consider the request, just because he said it. Michelle, welcome to the Secret Agents Club. Thanks for joining. What a great name, by the way. Yeah, Seagull is the only one who doesn't see it. She is. Okay. Between the October 10th phone call and the October 19th hearing date, Judge Gull prepared a scripted statement that would otherwise be used as her basis for finding that Rosie and Baldwin acted grossly negligent and with gross incompetence in their duties as defendant Allen's lawyers. It should be noted that Judge Gull later added to her list of allegations that attorneys Rosie and Baldwin also violated the rules of professional conduct. We've got a footnote at the bottom here. See page 12 of Respondent's Brief in Opposition. Okay, so we've read all that. It's noteworthy that Judge Gull makes these claims despite her own appellant attorney acknowledging to the Indiana Supreme Court that attorneys Rosie and Baldwin were very experienced and highly competent lawyers. Yeah, he did. Yeah, he did. Then he had to try and walk it back. That was a good moment in that hearing. It was. Okay. There exists a rational influence of bias and prejudice because Judge Gull formed this opinion. Worse yet, Judge Gull claiming on the record in chambers that she is finding gross incompetence on the parts of Baldwin and Rosie provides a rational inference of bias and prejudice. A judge that has predetermined an attorney is grossly negligent and grossly incompetent has developed a bias. It is! It's a bias. There's no other word for it. It's a bias. Okay, how's the poll doing? Oh. So there's 14% of people in this chat right now, watching this stream right now, who believe, now 15%, that she's unbiased. Interesting. All right. The mere reference to Rosie and Baldwin as being incompetent would be strong evidence of a rational inference of bias and prejudice, but claiming that she, Judge Gull, finds them grossly incompetent provides even more conclusive evidence of a rational inference of bias and prejudice. Judge Gull telling Rick Allen that she has grave concerns about Baldwin and Rosie representing him, so that was at the 31st hearing, provides a rational inference of bias and prejudice. And finally, Judge Gull, for the first time ever, allowing cameras in the courtroom, knowing her plans to ambush the defense and how cameras in the courtroom would impact the attorneys psychologically as they tried to process their options, provides a rational inference of bias and prejudice. It totally does. Ordinites in the chat, yeah. It's all the ordinists in the world. 15% of people viewing this stream right now. All right. 3. Judge Gull violated defendant Allen's due process rights. On October 19th, Judge Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming at the expense of Rick Allen and be removed from the case, or to voluntarily withdraw with the face of compromising Rick Allen's defense strategy. In the face of compromising Rick Allen's defense strategy. Despite defense counsel requesting clarification as to the topics and or motions to be addressed at the October 19th hearing, and absolutely Rosie asked, we've seen the emails. Judge Gull gave defense counsel no notice of her plan to force withdrawals or remove them, even though Slicky Nicky brought all his witnesses. So he knew. I'd love to know. I'd love somebody to subpoena their phone records or their emails, because they had to have had private correspondence. For him to bring like all of those, like who was there? Doug Carter and Holman and all these cops were there, right? Well, they didn't just get the urge to go and watch that hearing, did they? They all knew to be there for a reason. They had to have had private correspondence over it for all that to happen. So, denying counsel the opportunity to adequately refute her accusations. Judge Gull's failure to offer up to the defendant or his counsel the basic due process of the law creates a rational inference of bias or prejudice. Judge Gull spoke these words to Richard Allen on October 31st. She did indeed. That same day, Judge Gull had a prepared statement that she threatened to read to the public, alleging defence counsel was grossly negligent and incompetent in the representation of defendant Allen. Judge Gull's complaint was more about not having control over counsel rather than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defence. In support of Judge Gull's forced removal of attorneys Rosie and Baldwin, Judge Gull cited a number of different concerns, none of which formed a basis for the removal under Indiana law. Additionally, until the in-chambers hearing, other than the topic of the evidence leak, Judge Gull had never mentioned to counsel that the other items she mentioned in chambers were worthy of them being disqualified from the case. There is no way that the defence could have been prepared to refute or argue. For example, Judge Gull's apparent belief that Brad Rosie's filing of a tort claim notice to protect his client's rights was one reason that she thought that the defence should be disqualified. Absolutely. Judge Gull provided no preview of the topic she intended to discuss, which caused her to disqualify Allen's attorneys, other than the leak, and certainly never told the defence that she had already made up her mind to remove them from the case. In other words, the majority of topics Judge Gull raised with the defence as reasons for the removal at the in-chambers hearing were a complete surprise to the defence, and some people might not believe that, but we've seen the emails. What happened in chambers was a violation of Richard Allen and his attorneys' due process rights. Accordingly, the Indiana Supreme Court recently ruled on the 18th of this month that Judge Gull's actions were in removing Baldwin and Rosie were in error and reinstated attorneys Rosie and Baldwin as Richard Allen's appointed public defenders. This reversal of Judge Gull's removal of Baldwin and Rosie and refusal to accept their appearance as pro bono lawyers took place very publicly over the course of tense litigation pitting Judge Gull on one side and Baldwin and Rosie through their client's original action against Judge Gull on the other. Judge Gull chose to retain counsel to fight the original action. So that was the writ of mandamus. The highly public and contentious litigation between Judge Gull and Rick Allen, and therefore between Judge Gull and attorneys Baldwin and Rosie, provides a rational inference of bias and prejudice. That fact alone should mean that to any reasonable person that she is biased. The very fact that this went all the way up to the Supreme Court of Indiana and Richard Allen, as the relator, was pitted against Judge Gull, shows that even if she hadn't been previously, which she was, she certainly will be now. Seagulls nick your chips and then poop on you. They do. Judge Gull engaged in a critical stage proceedings in defendant's absence. On October 19th, Judge Gull conducted critical stage proceedings in chambers outside the presence of the accused, even though she ordered him transported and he was available to participate in the in-chambers hearing, placing his attorney in an ethical dilemma and creating a public record outside the presence of the accused. This ignored any sense of due process. It absolutely did. Daughter of Scotland, member for 30 months. You really are my oldest member, I think. I don't know anybody who's been a member for 31 months. So, okay. Well, yeah. And Rick Allen was prepared to go to Judge Gull's chambers and she wouldn't let him. Judge Gull engaged in a planned forced resignation of the defence team in her chambers. Okay, we know that. Judge Gull again referenced defence counsel's pleadings that contain her words, inaccuracies and falsehoods. The court The court's references were connected to the facts and circumstances surrounding the emergency motion to modify the safekeeping order that was denied by the court on the same day. The court instructed the Department of Corrections staff to stand down on the transport of subpoena defence witness. So that was Robert Baston, who wouldn't come out of his cell. And she told them, oh, don't worry about it. The court's own actions were and are prejudicial to defendant Allen's defence. Judge Gull's belief that counsel would provide false pleadings to the court, thereby questioning their integrity, exhibits a rational inference for bias and prejudice. Judge Gull demonstrated bias towards the prosecution. Ooh. What? In the days leading up to towards prosecution. All right, got you. In the days leading up to the October 19th hearing in Fort Wayne, Judge Gull, attorneys Baldwin and Rosie, and prosecutor McClelland participated in a phone conference to discuss matters associated with the dissemination of crime scene photos. So the leak. It was during this phone conference that Prosecutor McClelland first uttered the word disqualification. After a very brief discussion, Judge Gull communicated to the parties that she, at that moment, was inclined to grant the request. So it was Slicky Nicky behind all this. He needs to recuse himself and all. The comments were made by the court without having conducted even the most informal of hearings, without having considered any piece of evidence, without consulting with defendant Allen on the matter. Judge Gull's conduct of quickly siding with the prosecution on an off-the-record phone call on a matter of such high importance, i.e. illegally kicking off lawyers who have spent thousands of hours on the case and will be prepared for the January 2024 trial date. That's the real reason it all comes back to that. Demonstrates a rational inference of bias against defendant Allen and runs afoul of Rule 2.3. Judge Gull made public misrepresentations on the record. Immediately following the court's planned removal of the defence team, Judge Gull took to the bench and addressed all those in attendance, as well as the public at large, through the lens of a pool camera authorised by Judge Gull, broadcasting the proceedings to the general public and potential jury pool. In pertinent part, Judge Gull spoke the following words. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defence attorneys have withdrawn their representation of Mr. Allen. Yeah, it wasn't unexpected, was it? Maybe it was unexpected that they didn't come out fighting to be publicly disparaged. Maybe that's what she meant by unexpected. The court concluded the hearing by stating that, clearly, this is outside of our control. Well, that's not true, is it? It was entirely within her control. It was all her control. When referring to the events that took place in chambers, these words spoke untruths, as the withdrawals of Baldwin and Rosie were exactly what Judge Gull had pre-planned to happen. Her words to the public, therefore, appear to have been intended to disguise her in-chambers actions, which forced their resignation. And Judge Gull knew her actions were wrong, as later she tried to conceal what happened in chambers. When Richard Allen's original action lawyers, so that's Cara and Mark, attempted to obtain a transcript of the in-chambers hearing, Judge Gull's staff refused access to the transcript, calling it confidential. Richard Allen was therefore denied his rights to the transcript of a hearing wherein he was not present and wherein his lawyers were effectively severed from him without his consent. In order to review what happened in chambers on October 19th, Richard Allen's counsel on the original action were forced to request the Indiana Supreme Court to order Judge Gull to release the transcript. Allen's counsel made this request on November the 6th. On November the 8th, the Indiana Supreme Court ordered Judge Gull to release the transcript, and ultimately Judge Gull complied. So they had to tell her to release the transcript. Judge Gull's attempt to deny Allen's lawyers the transcript of the in-chambers hearing and to keep that transcript hidden from Allen's attorneys and from the public provides a rational inference of bias against Richard Allen and his defence team. The court's own words to the public at the October 19th hearing, claiming that the events were unexpected and were out of the court's control, are in conflict with Rules 2.1. She's just a big fat liar, in other words. Big fat liar. Judge Gull engaged in ex parte communications. Oh, I wish they could prove that. Okay. On October 30th, attorneys Rosie and Baldwin filed their private appearances on behalf of defendant Allen as his pro bono attorneys. The next morning, attorneys Rosie and Baldwin appeared in person in the Carroll County Circuit Court as defendant Allen's pro bono attorneys, with the ethical and legal duty to carry out their representation of defendant Allen. However, Judge Gull, with intentionality, refused to allow attorneys Rosie and attorney Baldwin to carry out their representation of their client. This included communicating by text message to Judge Gull's chosen replacement attorneys prior to the start of the hearing. Oh, that's bad. Oh, I so wish they could prove that she was having private communications with McClelland. That would be so good. This also included engaging in an in-chambers conference with said replacement attorneys and prosecutor McClelland, while attorneys Rosie and Baldwin remained in the courtroom with their client. Yeah, because she thought she'd get away with that. She thought she'd get away with that. You know, because they weren't his real attorneys. After taking the bench, Judge Gull, on her own volition, severed the attorney-client relationship for a second time without seeking the opinion and or permission from Richard Allen, the client. This sua sponte severance of the attorney-client relationship without the input and or permission of Richard Allen was prejudicial to his defence. The court's actions were not only violative of defendant Allen's rights, but also significantly impair any public transparency in the actions of the judiciary. Judge Gull denied defendant his Sixth Amendment right to counsel, and in doing so denied his right to a speedy trial. Judge Gull denied defendant Allen his Sixth Amendment right to counsel when she forced their resignation during the October 19th in-chambers hearing. Rosie and Baldwin then entered their appearances as private counsel for Richard Allen. This was done at Richard Allen's request. Absolutely got the paperwork. Richard Allen's intentions were to file a speedy trial motion and secure his previously scheduled trial date of January 8th. This is the real issue. This is what it all comes down to. Slicky Nicky was terrified. He was caught on the hop. He thought that there'd be continuance after continuance after continuance, and he wouldn't have to deal with that trial for months and months and months and months. And he could kick the can down the road for as long as he thought he could be allowed. No, they said no. They said, no, we are ready to go to trial on January the 8th. And this all kicked off. This all kicked off days later. Judge Gull prevented this from happening by refusing defendant Allen of his attorneys of his choosing. Judge Gull's refusal to allow defendant Allen's counsel of choice back onto the case effectively derailed any strategy defendant Allen and his lawyers had developing in effect to move his case into a courtroom and challenge the merits of the state's charging information. The judge's actions were per se prejudicial to defendant Allen in that he was denied of his basic constitutional rights of his choice of counsel and also his basic constitutional right to a speedy trial. By extension, the denial of his right to a January 2024 trial date was prejudicial to defendant Allen because he was returned to safekeeping within the confines of the same maximum security unit wherein he was unfairly detained and experienced both mental and physical deterioration for nearly a year prior to Judge Gull's Sixth Amendment violation. This is a lot. You know, we knew all this. None of this is new information, certainly not to me. I've been talking about this for months. However, putting it all together in one document, and I'm not even halfway through it yet, you just think, whew, whoa, it's a lot. It's a lot. Judge Gould changed her ruling in a prior order when attorneys Rosie and Baldwin were reinstated. Oh, God. Judge Gould received, I'm glad they brought this up. Judge Gould received the Franks memorandum on September 18th, 2023. She took no action on the Franks filing for over 4 months. She did, however, offer her chosen public defenders, Scremin and Labrator. Oh, what wonderful children you have. How beautiful they are, William. Oh, how proud you must be, she says to William Labrator on Facebook. So, however, to her chosen public defenders, the opportunity for a hearing while they were representing Richard Allen. This is evident from her November 1st order, wherein she offered up the following invitation. Court notes 2 pending motions, motion to suppress and motions for Frank's hearing, and will await a report from attorney Scremin and Labrator and prosecuting attorney McClelland regarding hearing dates. So she's ready to set a hearing. She's asking them for hearing dates for these 2 motions. She's going to hear them. She wouldn't be asking for dates if she wasn't going to allow the hearings, would she? Would she? She wouldn't. The court then memorialised this invitation to pursue these motions in a minute entry reflected on the CCS, so the docket, on November 2nd. Then again on November 14th. The court issued an additional minute entry again, inviting defendant Allen's new counsel to set a hearing on the pleadings. The entry reads, if defendant's new counsel inform the court they intend to pursue the Franks motion, the court will schedule a hearing. Boom. 2 business days after attorneys Rosie and Baldwin were reinstated, Judge Gould issued an order denying a hearing on the Franks motion and denying a motion in limine filed by Rosie and Baldwin regarding the admission of ballistics evidence by the state. What appears to the defence to be a hastily written opinion lacks any serious legal and factual analysis. Yeah, there's no legal analysis. It's just no. It's just no. I'm going to have to get a boom emoji. I need a good boom emoji. That's my next emoji. Somebody remind me because I'll forget. Oh dear. All right. Dear God. This is a lot. Baldwin and Rosie, they must be pulling their hair out. They really must be. They really must be. Never seen anything like it in your life. Meanwhile, in South Carolina, going on right now, I'm going to have to catch up on the replay. There's an evidentiary hearing going on right now because little Alec Murdoch can, he can afford attorneys. And, they're trying to get a retrial based on something that the clerk of the court might have said to one juror. And the judge is entertaining it all. And so she should. Because it's about transparency and due process. And it might be nonsense, but it has to play out like that. The judge is allowing it because it has to play out. It has to be on the record, transparent, every I dotted, every T crossed. There couldn't be a more different circumstance than this. This is outrageous, in my opinion. What appears to the defence to be a hastily written opinion lacks any serious legal and factual analysis. No, she just decided on an important issue. The absence of any real factual or legal analysis contained in Judge Gould's order begs the question of whether Judge Gould actually engaged in any meaningful review of the memo and attached exhibits. I bet she didn't even read it. I bet she didn't read it or even look at any of the exhibits. I bet she just didn't. I bet she just put it to one side and thought, nah, getting rid of these guys because my new friend, Slicky Nicky, he doesn't like it. He doesn't like it. The timing of the ruling and the lack of serious legal and factual analysis provides a rational inference of bias and prejudice against Richard Allen, most notably Judge Gull offering her chosen replacement attorneys the opportunity for a hearing on the pending motions while denying Baldwin and Rosie the same opportunities creates a rational inference of personal bias against Richard Allen and his current defence team. Yeah, absolutely. Totally it is. I mean, that's just common sense. You don't need to be a legal scholar. That's basic common sense, in my opinion. That's what it looks like. That's what it is. If it quacks like a duck, or should I say, if it squawks like a gull, and it waggles like a gull, and it's got to be a gull, right? Yeah. Judge Gull discredited Defendant Allen's defence team. On November 14th, Judge Gull issued an order that in pertinent part acknowledged Defendant Allen's filings of a motion for ranks hearing, memorandum in support, and the accompanying documentation. These documents have been filed by Defendant Allen on or about September 18th. Nearly 2 months later, Judge Gull, having taken no action on Defendant Allen's pleadings, invited successor counsel to either adopt those pleadings or make their own. Implicit within Judge Gull's verbiage is what appears to be the court's attempt to empower her chosen replacement, Scremin and Labrato, to abandon a material aspect of Allen's defence strategy. If there is any debate about the court's intentions, at the very least, Judge Gull's order and language therein creates the impression that the court is sceptical of Allen's defence strategy, thereby prejudicing the totality of his defence. I don't know. I don't necessarily agree that adopt these pleadings and make your own is prejudicial. I don't necessarily agree with that. I think that's just a statement. You can either adopt the pleadings and then I'll hear them, which she agreed to do, or make your own. Choose your own. Do your own work. Okay, Judge Gull committed violations of the Access to Court Records Act. Judge Gull did remove and seal or ordered the removal of the defence pleadings from the chronological case summary, in the docket, in violation of the Indiana Supreme Court's administrative rules. These pleadings include, there's a whole bunch of them. She just took them off. Just delete them. Just delete them. Get rid of them. So the Franks memorandum, 3 affidavits from the warden at Westville, Sergeant Jones and Sergeant Robinson, those 2 ordinists. The affidavit of the accused Leaker Mitch Westerman. Most recently, an affidavit signed by defence investigator Suzanne Moller and incorporated in the 3rd request for... Well, I've not seen that one either. I don't think I've seen that. Has anybody seen that? Affidavit signed by defence investigator Suzanne Moller. I don't remember that. Okay, and secreting the pleadings from the docket without following the ACR rules, Judge Gull allowed violations of public access. Because those acts are shielded documents, these actions demonstrate a lack of impartiality and fairness. Absolutely. Absolutely. How late are you? I've been live for, just look, nearly an hour, so you're quite late. So stick it on like 1.5 speed and then you'll catch up eventually. Judge Gull engaged in additional violations to the Access to Court Records Act. Defendant Allen's original motion to disqualify Judge Gull was filed by Attorney Rosie, and so the original, the first motion to disqualify that Rosie did, that was just deleted, got rid of on October 25th. October 27th, the court issued an order noting attorney's Rosie withdrawal, albeit forced, from the case and struck from the record substantive pleadings filed by Defendant Allen. Any authority the court had to strike the substantive pleadings from the record stemmed from the court's reversible error. Terminating the attorney-client relationship between Defendant Allen and Attorney Rosie, despite defendant Allen's objection. The court's conduct demonstrates the court's inability to remain impartial to defendant Allen. Absolutely. So bad. Judge Gull failed to address her administrative duties. Attorney Baldwin submitted his first billing Oh, we're getting to the nitty-gritty now. Attorney Baldwin submitted his first billing invoices on May 19th, 2023. Baldwin's staff left several communications with Judge Gull's office concerning Judge Gull's failure to sign off payment. She's not been paying him. She's not been paying Baldwin. No way. No way. As the months passed, those communications were basically ignored. The Carroll County auditor said they would pay the bill as soon as Judge Gull sent them an order, but they have not yet been sent. What? Seriously? That's insane. Flower of Scotland gifted 10 memberships. Thank you so much. Who's got them? All right. Sweet Peas, Cool Cat Lady, Graham 7, Betty Smith, Little Butterball. Who else? Pam, Wildman's Mom, Thunder Horse, Flicking Bollocks, and Dina. Welcome, everybody. Welcome. You've got a month's free membership, courtesy of the Flower of Scotland. You've paid for more memberships in the last month than I've lost count, Daughter of Scotland. I've completely lost count on how many people have become members. So, yeah, you've got some emojis you can use, you guys. Got some new emojis you can use. Okay, she's not paid him. I can't believe that. I can't believe that. That's insane. Finally, Baldwin personally sent an email to Judge Gull's staff, essentially begging to be paid. Eventually, Baldwin's attorney bill from May 19th was paid in full on September 18th, only a few days after Carroll County received an order from Judge Gull, but almost 4 months to the day that the bill was tendered. Attorney Rosie submitted his first billing invoice on May the 10th. Said invoices were not satisfied until September 19th. She's not paid either of them. She's not paid either of them for 4 months. Please read your comment above. I don't know whether I'll be able to find it. Sorry. I don't see it. I'm scrolling quite far up. Sorry. I've missed it and I can't find it now. I wish YouTube had like a search in the chat, like you could search for a specific person's comments. That would be really useful. YouTube, if you're listening, we needed the ability to search for specific users' comments. Because if you miss a comment and then you're asked to find that comment, it's almost impossible. But if you had a nice little search, it's right under the gifting. Right under the gifting. I'm still not seeing it. I'm sorry, I can't find it. Sorry. Okay. Since then, Judge Gull has failed and refused to authorize other payments of invoices submitted by Attorney Rosie. No way. So she's finally paid Baldwin's on September 18th, and she's still not paid Rosie. So they've done all that work essentially for nothing. I mean, they'll get paid eventually. They have to get paid eventually, but that's crazy. On October 4th, Attorney Rosie submitted 2 separate invoices, one for his own services rendered to Defendant Allen and a second for administrative expenses. No action was taken on the invoices up to and including January 5th. On this date, Attorney Rosie reached out to Judge Gould's court staff through email and provided summaries of various outstanding invoices that are yet to be processed by the court. These included invoices from Attorney Baldwin, which were submitted in early December, also yet to be processed. 4 days later, having received no response from the court, Attorney Rosie sent a second email requesting a status update. The court staff response was that the 3-month-old invoice had been forwarded for review. 1 day later, Judge Gould's staff informed Attorney Rosie that several invoices had been approved and forwarded to the Carroll County Clerk for payment. Several invoices were paid, including Attorney Baldwin's invoice submitted early December. However, as of the date of this filing, Attorney Rosie's invoices submitted nearly 3.5 months ago remain unpaid. That's insane. That's insane. Judge Gould's refusal to process the attorney's invoices in the normal course of business demonstrate a rational influence of bias against Defendant Allen. Either that or sheer incompetence. But no. I bet Slicky Nicky's getting paid. I bet Slicky Nicky's being paid on time. And further demonstrate a prejudicial behaviour towards his defence team regarding even about paying them. Furthermore, on August the 8th, Allen's attorneys requested that the transcript from the June 15th hearing, in which the defence counsel requested Allen be moved out of Westville for reasons important to the defence. Nearly 6 months have passed and the defence has not yet received the transcript of the June 15th, 2023 hearing. Judge Gould's failure to provide the transcript is another example of her contempt for the defence. Jesus. Judge Gould failed to protect the accused. Defendant Allen's unique and unusually burdensome detention circumstances have been a concern to his defence team since he was shipped off to the state penitentiary only a month or so after his arrest. These concerns were immediately brought to the attention of the court by the way of both in-chambers communications between Rosie and the court, as well as emails between Rosie and the court offering up a reasonable solution of the problem. After the court declined to take precautionary action, on April 5th, the defence team filed an emergency motion to modify the safekeeping order. The court's response to the emergency request was to set the matter for a hearing on June 15th, a full 2.5 months after the emergency motion was filed. In the interim, Westville inmate Robert Baston filed a pro se letter to the court corroborating some of the concerns regarding the detention circumstances surrounding Defendant Allen. I can't find your comment. I want heart to touch. I can't find it. I can't find it. If I could find it, I'd read it, but I can't find it. Like, I can see you saying, please read my comment, like several times, but I can't find the comment that you're referring to. And we're past where the gift memberships are. I can't find it. I'm sorry. Reposted above. No, because have you though? So I read that one. It's right under the gifting. And then And then you read my comment. And then I typed again. I can't, I'm sorry, I can't see it. It's an Amber Alert off topic. Is Siegel had it again? She's never been, you say if she's had it again, she's never been off it. So it's an Amber Alert. An Amber Alert for who? What's the name of the person? Thank you, Bug Love. Hey, GG, aka Bug Love. A new Amber Alert out of Kentucky. 5-year-old Layla, is that Leela Black, abducted by her father, Byron Black, after he shot his wife, Kelly Black. All right, let's Layla. What's her name? No, Layla Black. Kentucky. Okay. Amber Alert issued for missing 5-year-old Kentucky girl after mother found dead. Police have issued an Amber Alert for a missing girl after her mother was found dead Sunday. Layla Black, 5, is believed to be taken by a biological father, 42-year-old Byron Black. According to a post from the National Center for Missing and Exploited Children, police responded to a home in Princeton, Kentucky, Sunday and found a woman, Kelly Black, dead from a gunshot wound to the back of the head. Neither Layla nor her father have been seen since Friday. Layla is described as 3 feet 6 inches tall with brown hair and eyes weighing roughly 40 pounds. Black is described as 6 feet with brown hair and eyes weighing 180 pounds. An arrest warrant for Byron Black is being issued and he's believed to be armed and dangerous. The pair was last seen in a white Chevrolet Silverado with paint peeling from the hood and the California license plate 5J83779. Anyone with any information is asked to contact State Police at 270-676-3313. So that's from 2 hours ago. So that's not a great picture, is it? It's very blurry. Okay, so thank you for sharing that. Hopefully she's safe and he's arrested soon, very soon. Okay. So the defence subpoenaed Emmett Baston on June 15th, 2023. Attorney Rosie perfected service of the subpoena with the assistance of a Department of Corrections staff attorney. However, on the morning of June 15th, Judge Francis Gull in chambers informed attorneys Rosie and Baldwin that she had released Carroll County from executing the subpoena on Emmett Baston due to his resistance to being transported. Yeah, because he was scared. A hearing on the defence motion was then conducted, and thereafter the court issued an order denying the defence motion to move defendant Allen, and in fact suggested in its order the evidence submitted did not support many of the allegations advanced by the defence counsel. In paperwork filed with the court on June 20th, but sealed by Judge Gull until November, surprise, surprise, and only unsealed after the filing of a written mandamus against Judge Gull, it was revealed to the public that Judge Gull and or her staff chose to communicate with the state's witness, Tobe Leesenby, concerning Emmett Baston's unwillingness to attend a hearing. Legally speaking, the witness has no choice but to appear, and Carroll County had no choice but to honour the subpoena and transport the witness. Prisoners all over the state of Indiana are transported to hearings and trials that they may not want to attend. even if their refusal to attend is out of fear that their testimony will put them in danger. The proper method to deal with the situation would have been for Judge Gould to alert both sides about the problem and then conduct a hearing on the matter so that it is on record, which the Court of Appeals could review later if needed. Instead, Judge Gould, either directly or through her staff, opted to leave the defence completely out of the equation, surprise, surprise, and issued an ex parte off-record ruling advising the Carroll County Sheriff's Department and Westville Correctional Facility leave the witness at Westville, thereby ignoring the valid subpoena prepared and properly served by the defence for a witness that was expected to support the defence concerning Allen's treatment at Westville. In summary, Judge Gould released a material defence witness from a properly served defence subpoena and then claimed that the defence team failed to meet its burden of proving the allegations. Yeah, said they were lying. And that was one of her reasons to say that they were grossly incompetent. That was one of her reasons, that they lied about his treatment at Westville. Judge Gould's actions were prejudicial to defendant Allen, and her actions usurped, I can never say that word properly, usurped defendant Allen's ability to prosecute his own emergency motion. Jesus Christ. Honestly. It's insane. Judge Gould's continued and ongoing failure to protect the accused. Judge Gould has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. On 2 different occasions, the court has been asked to order the removal of Richard Allen from the Westville Correctional Facility and place him in a less restrictive and healthier environment, as he is pre-trial. He's pre-trial. The court denied both attempts. At times following these denials, the court has taken the position that allegations offered up by defence counsel were untrue. Most notably, the court accused Attorney Rosie of misrepresenting truths about his detention and used this as support for Judge Gould's findings that the defence counsel engaged in gross negligence. Yeah, I just said that. Insane. Mr. Allen, as if the warden at Westville is going to come and tell the absolute truth. Yeah, we abuse our prisoners. As if the warden's going to say that. Mr. Allen's replacement attorneys filed a 3rd motion requesting his transfer in early January of 2024. The allegations in the motion address ongoing connections between ordinists, but anyway, employed by the Department of Corrections, who had continued to be in contact with Mr. Allen. Former counsel Scremin actually offered up a photo of one guard who was so bold as to tattoo. He had his face tattooed. While knowing that his ordinate connections had been previously called into question by the defence in formal pleadings. It's like he tattooed his own face. How insane is that? In addition, there are new claims that Mr. Allen continues to be detained, i.e. shackled, like Hannibal Lecter. He spelt Hannibal wrong as well. Scremin spelt it wrong. He's now spelt it wrong. Unnecessarily, and has now been moved, apparently without any judicial involvement, to a facility some 233 miles from replacement counsel, Scremin and Labrato. The court continues to take no action to protect Mr. Allen. This is not an adversarial matter or issue. The state should be an uninterested party in this matter. There is no need for the introduction of evidence in support of these claims. The court has an absolute jurisdiction of Mr. Allen's detention circumstances. It would be entirely appropriate for the court to err on the side of caution and engage in remedial measures to ensure Mr. Allen is being housed under humane circumstances for a pre-trial detainee. Ballosi. Ballosi. They're trolling with Ordinary. Maybe they are. Dear me. Dear me. It would be entirely appropriate for the court to order the detention of Mr. Allen in a facility close or near to his court-appointed attorneys so that they would have a simple convenience of communicating with him in person. Oh, they couldn't do that. No, nothing could be simple in this case. And under reasonable conditions, without the necessity of lengthy sojourns, each and every time they desire to meet with Mr. Allen to prepare his defence. Attorney Rosie had even arranged for the Cass County Jail, literally a 2-minute walk from Attorney Rosie's office, to keep Richard Allen in pre-trial detention. This request was denied as Judge Gult sided with Carroll County Sheriff's Department due to its confusing claim that the sheriff would have difficulty transporting Rick Allen 20 minutes from Logansport to Delphi, when it was taking much longer than that to transport Richard Allen from Westville to Delphi. The court's refusal to intervene is prejudicial to Mr. Allen and in violation of 2.3 of the CJC. The court's refusal to intervene violates Mr. Allen's Sixth Amendment right to present a defence that runs afoul of his due process rights under the state and federal constitutions. Yeah, well, she rides roughshod over the Constitution. She doesn't care about any of that. Judge Gult's failure to take common sense measures to move Richard Allen out of Westville, especially after it was proven that he was guarded by practicing paganists, Ordinite. Oh, he said it right this time. Ordinists. When evidence and allegations that Ordinists were involved in the murders provides a rational inference of bias against Mr. Allen. Judge Gult has treated the prosecution more favourably than the defence. No shit, Sherlock. Throughout the entirety of the Franks memorandum, the defence detailed and provided evidence exposing false and or contradictory sworn testimony by law enforcement and even the withholding of exculpatory evidence by the prosecution. So what's this? Exchange occurred in emails. Oh, interesting. Oh, yeah. We knew that. Okay. Exculpatory evidence by the prosecution. Judge Gult did not have to read too far into the Franks memo to find these intentional acts on the part of the state. Alleged by the defence, as many of the most egregious intentional behaviours of the state were referenced in the first 25 pages. Yet she didn't read any of it. She did not read any of it, in my opinion. She didn't read any of it. Has Gult obstructed any previous other trials? It's a good question. I don't know the answer to that. Will she face any sanctions by not going by the rule of law? You would think so, but not that has been made public. Oh, Paul Ferguson's sentencing is delayed till the 26th of February. Is he Paul Ferguson? Yes, he's Paul Ferguson. Yeah. Okay. State of Indiana was continuing to provide large quantities of discovery even into October, nearly 10 months after Rosie and Baldwin entered their appearance, causing Rosie and Baldwin to seek a discovery deadline. Despite the state's intentional behaviour, including the non-disclosure of exculpatory evidence, Judge Gult has focused her ire on Rick Allen's counsel for what she claimed was gross negligence. Oh, well, Slicky Nicky has slipped in that document saying, well, they've not provided us any discovery. Yeah, but they were told to cease work on the case as of October the 12th. So what are you going to do? For example, Nick McClelland was in possession of highly exculpatory document prepared by Officer Todd Click's own lawyer, in which Click alerted McClelland that he, Click, was concerned that McClelland had not been informed about Click's involvement in investigating a group of men who he believed were involved in the murders, evidence that third parties involved in Odinism had murdered the girls. McClelland held onto that highly exculpatory document for nearly 4 months without turning it over to the defence. I'm surprised he didn't shred it and deny all knowledge. McClelland's failure to turn over the exculpatory documents also prevented the defence from questioning investigators about the exculpatory information during defence depositions in early August. This failure on the part of the prosecutor will require additional depositions and prolong the discovery process. McClelland's failure to turn over exculpatory documents is accurately detailed in the Franks Memorandum. Despite these truths, Judge Gull has never, not one time, chastised McClelland. No, could he do little Nicky boy, little Nicky. For these wrongs, Judge Gull never told McClelland that his behaviour appears intentional or grossly intentional, or at least grossly negligent. Dear me. Yeah, because they did say in the memorandum that they'd received some information that they'd not been able to look at yet. Judge Gull never indicated her belief that McClelland should be replaced, nor did she ambush him in an in-chambers meeting after allowing cameras in the courtroom to tell him that she was kicking him off the case. In fact, on page 16 of the transcript that the Indiana Supreme Court ordered Judge Gull to release, Judge Gull even states, "I am not accusing the state of gross incompetence or negligence. I am finding gross incompetence or negligence with you." The fact that Gull has solely focused her on her perceived belief that Rosie and Baldwin were grossly negligent and incompetent while not addressing the prosecution's provable discovery issues provides a rational inference of bias or prejudice against Richard Allen. Judge Gull engaged in unacceptable extrajudicial activities. Oh, dear. Oh, no. Oh, Facebook alert. Facebook alert. I'll just put this on the screen for a bit. This Amber alert. We'll keep that up for a bit. Okay. On July 9th, 2023, someone who is believed to be Judge Gull's then daughter-in-law published an entry on her own Facebook page stating the following: "What an honour it was for the girls to play in the Abby and Libby Memorial Tournament. What a great honour it was that Abby and Libby's grandparents presented our girls with their championship finalist rings." In spite of being the presiding judge in this case at the time this message was posted, Judge Gull made a choice to publicly comment on the post with a simple "congratulations." While this post may appear to be an innocuous comment to Richard Allen's counsel, it raises fair questions as to whether or not a rational inference of bias and prejudice exists. As the presumable relatives of Judge Gull who are mentioned in this post will likely see Judge Gull from time to time. Facebook post was not included herein as it contains photos and names. Okay. Time to time, communicate with Judge Gull and have opinions concerning the murders of Abby and Libby. And Judge Gull must know that her relatives may have been emotionally impacted by their involvement in the softball tournament, especially from interacting with Abby and Libby's grandparents. Yet, knowing all of this and knowing that Judge Gull will be challenged with resolving evidentiary and procedural disputes in this case, she chose to comment on that post. Well, she tells William Libretto that he's got beautiful children, so... Okay. In 2013, the American Bar Association issued formal opinion and 462 entitled "Judges' Use of Electronic Social Networking Media." While the ABA acknowledged that electronic social networking media, that's very awkward. can be beneficial, judges were cautioned to be conscious of the way their online relationships appear to others. Under the Model Code of Judicial Conduct, judges are obligated to maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety in their professional and personal lives. In other words, your Facebook profile needs to be in someone else's name. That's how we get around it in this country. Just make up a fake name and tell your family and friends that that's your Facebook name. Anyway, I don't know. Judges must therefore be very cautious in their use of electronic social media, as online communications and friendships taken out of context can create the appearance of bias or impropriety, therefore undermining public confidence in the judiciary. Public commenting on a post concerning a softball tournament that honoured the victims in this case provides evidence of a rational inference of bias. Certainly the perception of it. It doesn't necessarily say she's biased on its own, but it to the public, it does look like she is. And I think that's the point. Timing of judicial bias, prejudice, and lack of impartiality. Okay, so RPC 2.4 requires that good cause be shown when any movement, is that a word? For a change of judge cannot meet the 30-day timing required, referenced in subsection 1 of the rule. Defendant Allen asserts that the first time Judge Gould's bias was cemented in the minds of the defence, demonstrating her bias, prejudice and lack of impartiality, occurred during a phone call between Prosecutor McClelland, attorneys Rosie and Baldwin and the court. This phone call occurred on October 10th. During this call, Prosecutor McClelland made a fleeting reference to the potential disqualifications of Rosie and Baldwin. Without very little hesitation, Judge Gould suggested that the court was leaning towards disqualification and thereafter ordered the parties to appear in her Allen County courtroom on October 19th. It was at this hearing that the court staged premeditated severing. Okay, so we know all this. The claim contained herein, some of which occurred prior to the October 10th phone call, believed by Richard Allen to be pieces of a puzzle, the totality of which illustrates the court's bias, prejudice, and lack of impartiality. To Richard Allen. Some of the factual matters that show a rational inference of bias occurred before October 10th. The defence assert that some of Judge Gould's questionable behaviours that predated October 10th were not signs of bias. However, when placed into context, Gould's actions predated October 10th are now viewed as evidence of a continued pattern of bias, which they absolutely are. So the failure to pay, as if it's not even coming out of her own, it's not coming out of her own personal bank account, is it? Obviously, neither attorneys Rosie and Baldwin had the authority to file any pleadings in this matter after October 31st. And if they'd done it before, like they tried to, Rosie put in a disqualification motion, and she just deleted it beforehand on the 25th. Therefore, Baldwin and Rosie could not file their motion for change of judge until after the Indiana Supreme Court placed Rosie and Baldwin back on the case. It is from this set of circumstances that Richard Allen asserts his claims in support of his motion. Signed, Richard Allen. So, we've got to wait for a reply now. But there is one more. There's one more. Let me just load this up here. So this is just 8 pages. State's response to defence's motion for transfer. So I'm just going to go and get myself a drink because I actually feel in my mouth that I've been sucking on a seagull for about the last half an hour. So I'm just going to run and get myself a can of pop. Please hold. I'm back. Pepsi or Coke? Pepsi every single time. Every time. I actually quite like cherry Coke, but Pepsi Max is my drink of choice. So let's have a see how this poll's going. Okay, we'll end this poll now. So 13% said no. They didn't think she was unbiased. And then 86% thought she was. 441 votes. Coke Zero's okay. Yeah. I just prefer Pepsi Max. Yeah, we do have cherry Pepsi. I've got 24 cans of cherry Pepsi actually. I got my shopping delivered yesterday. 24 cans of normal Pepsi Max and then 24 cans of cherry Pepsi Max. They did these flavors like raspberry flavor and like they do like these limited edition flavors, and none of them really. The raspberry one was too sickly. There was a couple of others. Was there a ginger one at one point? Can't remember. Maybe that was something else. But yeah, I do like the cherry one. So, all right. I'm going to take this Amber Alert down, but this is an Amber Alert out of Kentucky. It's a little 5-year-old girl called Layla Black, and her mother was found shot to death, and her biological father has, it looks like, has kidnapped her. They're driving a silver Chevy Silverado with California tags. So that's an Amber Alert out of Kentucky. So I'm going to keep my eye on that case. All right, so we've got one more filing to go through. Vanilla. Oh, yeah, there was vanilla. Yeah. Oh, no, I didn't like that one. And I do like vanilla. I do like vanilla flavor. Like I like vanilla ice cream. But no, it didn't work for me. Didn't work for me at all. Oh, no, I don't like cream soda either. I like soda water, but I don't like cream soda. All right, let's get on with this. The little break there. Iron Brew. Oh, yeah, Iron Brew's brilliant. I love Iron Brew. It reminds me of being at primary school or elementary school for you Americans. Because it was before they've got all like really like stupid in schools over here. Like you're not allowed to take cans of pop anymore. you've got to take water. Or I don't know if is fruit juice allowed. I don't know. But I used to have dairy on white bread. Dairy is like a kind of cheese, like a really fake cheese. And a can of iron brew for my lunch every day. It reminds me of school. Iron brew made in Scotland from girders, yeah. And my best friend used to love Tizer. Do you remember Tizer? I don't think they still sell Tizer. They still sell iron brew. I do occasionally get a can of iron brew. Tizer, yeah. We nearly came to blows one day, me and my friend, like which was best, Tizer or iron brew. We were like really, really going for this argument. No, this is better. No, this is better. Never heard of iron brew. Maybe they don't sell it anywhere else. I don't even know whether it's actually made in Scotland. Tizer's still going, is it? Oh, wow. Puzzled about Vegemite. Is that Marmite? We don't have Vegemite here in the UK. I don't think we do, but we have Marmite. Dandelion and burdock. That's good as well. Yeah, I sometimes get done. Vimto. Listen, I'm telling you what. If it's not Pepsi Max, it's Vimto. Vimto is my it's my best drink apart from Pepsi Max. Vimto's brilliant. I had a can of Vimto the other day. Very nice. Ginger beer. I like ginger beer as well. You have iron brew in South Africa. Vegemite is on sale in the UK. I always thought Vegemite was just Marmite. Like it was just called something else elsewhere. But I've never liked Marmite. I've never liked it. Lilt's good. Yeah, I quite like Lilt. Dr. Pepper, no, I'm not a fan. Oh, Bovril. My mother used to drink Bovril. Was it my nan? I can't remember. One of them used to. It was my nan. She used to drink Bovril. Ugh. My mum used to eat Marmite on toast with beans on it. And she'd say to me that if you put baked beans on top of Marmite, it tastes like cheese. It's like, yeah, well, why don't you just have cheese then? Like, if you want cheese on toast, just do cheese on toast. Why do you have to do Marmite and then beans on top to get a flavour like cheese? I don't understand. I don't understand. Bovril, it's a drink. It's like, I've never actually tasted it because it always smelt disgusting. It's like a paste and you put it in water and it tastes like meaty. It smells meaty. It's just horrible. My nan used to put it in like hot water and drink it. There's no meat in it, is there? It just smelt like meat. It's just horrible. Horrible. Iron Brew is 100% Scottish, created in 1901 by A.G. Barr. Really? That's cool. Who calls it pop other than Texans? We call it pop over here. Never can of pop. Some people say soda, kind of soda, but it's mainly pop. Certainly in the north here, we say pop. Call it pop in Wisconsin. All right, okay, I'm going to stop the pop talk and the Bovril talk, and we'll get on with this. Right, so this is the final filing that I've been able to find. If there's more, if more has come out today. I don't think I'll be able to hack any more reading. But yeah, this is just 8 pages. So this is the state's response to the defence's motion for transfer. So if you remember, it was Scremin and Labrato that put in this really interesting filing about Richard Allen's treatment in Wabash. So they'd been to visit him once in Westville and then once in his new place at Wabash, and both institutions, they said, were terrible. Like, there's just their treatment, the way that Richard Allen was treated, it's just far beyond anything that they've ever experienced with any other client. So this is Slick Nick's response to that filing. So it was actually signed by Robert Scremin. So Nicky is now replying essentially to the old defense. So, all right. So Nicky McClelland, and respectfully informs the court that the state has no preference of where defendant is held pre-trial. Now, he has commented previously and put witnesses on the stand in a hearing to say that Richard Allen's treatment at Westville wasn't bad. So this will be interesting to read. But the state believes it is in the best interest in the case, as an officer of the court, to inform the court of the exaggerations and inaccuracies outlined in the defence's third motion to transfer. So although they have no opinion, he has no opinion on where Richard Allen is housed, he's going to offer up an 8-page document. Has he got nothing better to do? So he's no opinion on this. However, he just feels it's his right, it's his need. You know, he needs to put this out, that all this was inaccurate and exaggerated. 8 pages he wants to put out there. All right. It sounds to me like he does actually have an opinion. You wouldn't write for 8 pages if you've no opinion, would you? Anyhow, all right. The state would ask the court to consider the following. Charges were filed against defendant Richard Allen on October 28, 2022, 2 counts of murder, we know that. That the Carroll County Sheriff's Department requested that the defendant be transferred to the Indiana Department of Corrections for safekeeping, and said request was granted. Yes, it was granted. Wasn't it granted on the same day that Judge Diener recused himself? Wasn't that the thing? Yeah, it was. The defendant was transferred to Westville on November the 3rd, 2022. The defense filed an emergency motion to modify the safekeeping order on April the 5th, which was denied. Yeah, it was denied. It was denied because Francis C. Gull was a dickhead, okay, in my opinion. That the defense then filed a motion to reconsider request for due process hearing on May the 3rd. The hearing was held, after which the court denied the defence's motion to modify safekeeping order, stating that the allegations advanced by the defense were not supported by evidence presented. Yeah, that's the June hearing. That's the June hearing, which Robert Baston refused to come out of his cell. Gull cancelled the subpoena without notifying the defence, and then the state put the warden of Westville on the stand as if he is going to tell the truth. So it's nonsense. The court added that the defendant was being treated more favourably than other inmates housed at Westville, according to the warden. According to the warden. All right, I will. Okay. Let's imagine that this could be possible and this would be granted. A camera crew follows Richard Allen around Wabash, and not like a full crew, but an external body, an external person could go and set up a camera for a day in Wabash, but they're not going to tell the guards and they're not going to tell the warden when that camera is going to be there. Imagine that was possible. You could get a camera into Wabash, a decent camera into Wabash and actually film what's going on. Who would be the party that camera would depict? Which party would most accurately reflect what actually goes on? Would it be Rosie and Baldwin and Stremin and Labrato, who have all said that his treatment is way different than any other pre-trial detainee that they've ever had to visit, that they've ever represented? In the many, they've all had over 20 years of experience as defense lawyers. So I bet you add them all up, it'll be close to 100 years. I bet you any money it would be close to 100 years experience if you combined all of their collective, visiting clients in prisons and jails and stuff all over Indiana. Or, so those four are the warden of Westville. Who would be the most likely person to be true, to be speaking the truth? I would back those four attorneys any day than a warden. The court made a finding that it's reasonable and necessary to house the defendant in Westville to ensure the defendant's safety, to prevent serious bodily injury to himself. So what are we saying here? That he's suicidal? Are we saying that he's suicidal and he has to be in a Department of Corrections because of that? So are we saying that a county jail can't deal with somebody who is suffering from a mental illness? Not that we know that Richard Allen is, and Slick Nick doesn't know that he is either, because Slick Nick has been rightly denied Richard Allen's mental health records. That the defence then filed a verified motion for immediate transfer of custody, alleging additional mistreatment. That, once again, the court stated that defence assertions were factually inaccurate and were refuted by the evidence that the state provided, therefore denying the motion. Nonsense. That the Department of Corrections then transferred the defendant from Westville to Wabash Valley Correctional Facility. So this was recently, like last month. That the new counsel for the defence has now filed a third motion to transfer. So he must have written this some time ago, because this is not the new counsel. We're now talking about the old counsel, the interim counsel. So Slick Nick needs to change that to old counsel now. Because it was Scremin that filed that. That the state has no opinion, yet right, it's an 8-page document. The state has no opinion where the defendant is housed during the pendency of this case, as long as he is kept safe. However, the state believes that it is imperative for the court to have accurate information in order to make its decision, whether it's lacking from the defence motion to transfer. So this information now that he's putting out is going to be true and proven fact, that he has no opinion of. However, he's just putting this forward just as a little helper. He's Judge Gull's little helper. It's like Santa's little helper. All right, he needs to go back to Lapland or somewhere, doesn't he? All right, okay. Oh, I can't with this guy. The counsel for the defendant referenced the emergency motion to modify safekeeping order filed by previous counsel, so now current counsel, and how they find the allegations in that motion meritorious. So it's got merit. That the motion has already been litigated at length and court has found the allegations outlined in that motion were without merit. Doesn't mean they weren't true. Counsel references a letter written by inmate Robert Baston at Westville stating that the defendant is being mistreated as a fact and to be taken as true. However, prior counsel, which is now current counsel, subpoenaed this inmate to testify at a hearing, and the inmate refused to leave his cell to attend the hearing. Yes, and he was subpoenaed to attend, and Judge Francis Gull didn't abide by that subpoena and said, oh, it doesn't matter, just leave him there. The reason why he didn't want to come was because he was scared. The state has documented Robert Baston's history with the court in prior hearings and filings with the court. The allegations by Robert Baston are not reliable evidence provided as sworn testimony. Maybe they're not. Maybe they're not. But is he saying, right, take Robert Baston out of it. Assume that Robert Baston has never spoken, has never written one letter, can't even write, can't read and write, is completely illiterate. He has not contacted the court at all. Imagine that's fact. You've still got the words of 4 very experienced attorneys all agreeing that Richard Allen's treatment and his determined and how they meet with him and how difficult it is to meet with him, are you just going to ignore all of that? Are you going to ignore that? Dear me. Jean, thank you for the €10. Thank you so much. Very kind of you. Yeah, county jails are people who are like Brian Koberger is in a county jail. He's in Lator County Jail. So you're basically being held, you can't get bond, you can't pay your bond, or you don't have a bond, or it's just ridiculous, a $20 million bond or whatever, right? So you're a pre-trial detainee. Also, if you've got like a small sentence, like under a year, you tend to be housed in a county jail. Over here, we don't have a distinction between county jails and prisons, but we do have, so it's all prison. We use the terms interchangeably, actually. But technically, they're all prisons, but there's different categories of prison. So you've got like your maximum Cat A prisons are like for really like nasty, seriously deranged people, maximum security. And then you have levels down. So Cat C is like really low level. So like if you, I don't know, like petty theft or stuff, you go to a Cat C. So although we don't have county jails, we have like lower level prisons where there's more scope for, more freedoms and stuff. There's also open prisons here in the UK. Open prisons, you can actually leave, like you can actually have a job. Like you can leave and go to work, and then you come back basically to prison. But you're supervised. You're not just like running rampant around the streets. You're supervised. So we have a similar but different kind of circumstance. I actually like the distinction between a county jail and a prison. I like that. Anyway, okay, let's move on. All right, so that counsel for the defence reasserts that the defendant is being mistreated by guards at Westville who practice Odinism. Again, this issue has already been addressed in a previous motion and was found not to have merit, and the motion was denied. That's nonsense. That's nonsense. The 2 affidavits by the 2 Ordinist guards actually admitted They said they weren't ordinists and they weren't racist and extremists and stuff. However, they practice Norse pagan heathenry, which could be mistaken for Odinism. And they were wearing Odinist patches. And now one of them has gone on to tattoo his own face. When told he better stop wearing the patches, he took the patches off his uniform and instead tattooed his own face. Does that's a fact. That's an actual fact. So you can't say it doesn't have merit because it's a fact. Look at his face. His face has a tattoo of an Odinist symbol on it. Come on now. And the motion wasn't denied. Those affidavits were taken off the record. She just deleted them off the record. I can't with this guy. Is he deliberately trying to annoy me, or is he just completely incompetent? Is this intentional or incompetent? I can't decide which it is. What a freak. Yeah, what a freak. Yeah. That defense then made the allegation that the defendant was denied recreational time and showers at Westville. The defendant has never been denied recreational time or showers at Westville. Okay. How does he know that? How does he know that? How does he know? Has he been there? Who was he asked? Who was he asked? Has he asked Richard Allen? Or who? Who? Or has he just decided? Where's the evidence? Where's the evidence that he's been there and seen Richard Allen having regular showers and regular rec time? How is she with this in the US? I don't know. I'm beginning to think that this is some kind of like Soviet state. This is it's like some freakish alternate universe. It's just that when the defendant was moved from Westville to Wabash, he made statements about committing suicide. Did he? Don't know about that. As a precaution, he was examined by mental health professionals and they determined that he should not be given rec time until they can be sure that he would not hurt himself. Really? Does anybody remember that? Does anybody remember that? Where was that information? Where's Slicky Nicky got this information from? I don't remember seeing this coming out. So he wasn't given rec time because he was suing. Oh, yeah. I do remember this. In that document. Yeah, I do remember this. That's what was said. Once he was off suicide watch, his recreational time resumed. Yeah, I remember something about that in that document because I remember saying, if you denied rec time and you're suicidal, sure, it's better to give you rec time because exercise is good for you. Like being able to see the outside world, just be able to breathe some fresh air is good for you. Whether you're suicidal or not, it's good for you. That council next complain that the check-in process at Wabash is too burdensome and time-consuming. The state was able to review video footage from council's visit. Oh, they've got evidence. They've got some actual evidence. All right, let's listen. This is good. Okay, so they've got some video from Wabash. Counsel for the defendant arrived at the facility at 12:35 and were processed to visit with their client by 12:58. Wait time was extended on this date due to a power outage at the facility, but in total lasted about 23 minutes, not the nearly 1 hour alleged in the pleadings. Okay, all right. that the facility typically does not allow face-to-face visits. Okay. So you're not allowed. So in Wabash, no one in Wabash is allowed a face-to-face meeting with their attorney. Are you kidding me? Seriously? Surely. Oh, my phone's ringing. One moment, please. MBs. 64 MB. Sorry, guys, I'm still on the phone. 64 MBs. It says error, request CV pixel buffer for frame returned, free for absolute frame 578. I have no idea what that means. I have zero idea what that means. Right, well, I'll just figure it out. All right, I've never had a message like that. Neither. Right, sorry for interrupting. All right, no worries. Right, see you later. See ya. I have no idea what he's talking about. No idea. Sorry about that. All right, we're back. Okay. Where was I? Oh, yeah, there I was. So Wabash does not allow face-to-face visits at all. Now, I know you can hear my conversation. It was just nonsense. It was something to do with exporting a file from iMovie and getting an error message. I don't know what the error message was. Why is a prosecutor allowed to watch a video of the defense meeting with their client? I'm assuming it was just like going into the prison. That like it wasn't an actual meeting video. It was them going into the prison. But he's now talking to attorneys who are no longer on Richard Allen's team, who can no longer now reply because they're no longer on Richard Allen's team. So he can make up any old thing. He can make that up. Absolutely, the unraveling. The defence has been denied the opportunity to view the conditions of their client's housing, but the state can access Department of Corrections surveillance anytime. Does a motion not need to be filed? It's crazy. It's crazy. I'm assuming it's the surveillance of them going through security at the prison. I'm assuming that's what it is. But the nearly an hour thing that they mentioned isn't just about going through the security, like to get into the prison itself. It's then having to go through the prison to have access to Richard Allen. That's also included. That wouldn't be on this little cute video that Slicky Nicky's got. And for somebody who has no opinion, he's certainly gone to great means. He's put himself out, you know, by contacting Wabash and getting video for something that you've got no opinion on. I don't think so. You know, it's something that you've had to, you know, ring up and request. And I bet he's been paid. I bet his bill's been paid. Oh, this is crazy. This is nuts. This is complete and utter nuts. Total nuts. So we're now in a facility that doesn't allow face-to-face meetings. I'm sorry, I don't believe that. If anybody has ever been to Wabash, like been an inmate in Wabash or has visited someone in Wabash, has had a relative or friend in Wabash, then what was your experience? Is it true that there's no face-to-face meetings? I mean, maybe there's no face-to-face meetings when COVID was a thing, you know, when COVID was rampant. Maybe then, like, prisons weren't doing face-to-face meetings, understandably. But I just can't believe that. But they accommodated the council. Okay, they accommodated the council. All right, great. And set up the defendant in a special room, seated behind a door that was see-through and had a slot where documents, papers, and whatever could be passed back and forth. See photographs attached as States Exhibits 1 and 2. So they've got photographs. Oh my God. So the defense said that was 8 inches high. So it fit a feed tray through. What's that? So it was in a kitchen. It was set up in a kitchen. And you can see that there's kitchen appliances and stuff. There's like a broom. So it's a great room. You know, you've got like a broom or a mop or something. You've got pans. You've got that looks like a wheelchair there. So it looks like a storage room. And presumably that's from the other side. So that's inside the cell. And then that's looking from the cell to the outside. Great. Cool. So for somebody who's got no opinion, that's a man's idea of inches. So for somebody who has got no opinion, he's been able to source a photograph. So he's got somebody to go into that cell and take a photograph and then go outside and take a photograph. So somebody's specially gone to photograph that particular area. And he's also had them send him surveillance video. Well, they said it was a room like off the kitchens. That's what they said. So it is. I think it is that they look like kitchen supplies. They look like cleaning supplies. It's some kind of storage room. But there's a table there. Look. There's a table there. So that must have been the table that they were allowed to sit at. But if you remember, they said that they weren't allowed to approach the door. So how could they pass papers and things through the door? Because they weren't allowed to step within 6 feet of the door. So unless you have arms that are longer than 6 feet, or you have like some kind of tool where you can pass the papers via a tool through this slot in the door, then how could they pass papers back and forth? Because they weren't allowed to approach the door. They had to sit on the opposite side of the table more than 6 feet away. some people getting buffering. It's not buffering on my end because I can see what you can see on my other screen and it looks fine. That's crazy. It's crazy for somebody with no opinion has gone to these lengths. Great. All right. Brilliant. Brilliant. Surveillance camera was present in the room that records movement only and no audio recording. Well, I'm sorry, I don't believe them. At this point, I don't believe them. The only thing that was recorded from the visit is when counsel entered the room and when they left the room. That, to the state's knowledge, any jail, the attorneys visit and meet with their clients is video recorded or monitored in some fashion. That is for the protection of the attorney and the defendant. That neither attorney brought a computer with them to provide the defendant with what? That neither attorney brought a computer with them to provide the defendant with a review of video or audio discovery, even after Department of Corrections made accommodations for them to do so. Okay. So we're going into some detail here, Nikki. Going into some detail here. But the point is, if they'd wanted to, they wouldn't have been able to. If they wanted to show him a video, they wouldn't have been able to. Because they had to stay more than 6 feet away. And yeah, they could have shown it, but then he'd have had to peer through this 8-inch gap. Just wouldn't have been very easy. Not conducive to a meeting that is covered by attorney-client privilege, I would argue. So defence were told by legal counsel for the Department of Corrections that if they needed anything additional to meet with their client, just ask and accommodation would be made for them. Cool. That each request that counsel for the defendant have made of Wabash has been granted. Okay, how about a meeting face-to-face that's not in some kind of kitchen storage room and your defendant is not behind a door with an 8-inch gap and you're allowed to at least you're allowed to approach that door. I mean, what's Richard Allen going to do? What's Richard Allen going to do? You know, if they approach the door, what's he going to do? All this is to say that the allegations that the defence outline are exaggerated and misleading. They are able to meet with the defendant, show him discovery in whatever format, and meet with him in an effective way. This seems to be more of a motion about convenience for them instead of zealous representation of the defendant. So it's a good job that Scremin and Labrato are no longer on the team, or else they would have been disqualified as well, because it seems that Slicky Nicky didn't like those guys either. That the state has pulled the records from Wabash Valley Correctional Facility, spoke to legal counsel for the Department of Corrections, and reviewed the video surveillance from Wabash, and the allegations put forward by the defence are inaccurate. That the defendant has a tablet in his cell that he can communicate with his counsel at any time and has said tablet since he has been there. Great, cool. I'm glad. That in addition, since the motion has been filed by the defence, the Department of Corrections has set up video conferencing so that the defendant can now meet with his counsel via video. That's great. That's cool. But not really private though, is it? Because that video recording is going to be recorded, isn't it? I don't know. That the defendant has commissary in his cell, where other inmates do not. Cool. That the defendant is being treated far better than any other inmate in the Department of Corrections. So again, this is we're now verging on opinion that has been said before, blah, blah, blah. That the state also spoke to Sheriff Dan whatever, from Adams County, and he is not willing to accept the defendant in his facility. So Adams County said no. He does not have sufficient space or accommodation to house the defendant. The Adams County Jail also does not have the mental health professionals available to address the defendant's mental health needs. Well, how does Slick Nick know what Richard Allen's mental health needs are? Because he's been denied, rightly, access to Richard Allen's mental health records. So how does he know what Richard Allen's mental health needs are? Has he been supplied with mental health records under the table? Don't tell anyone, son, that kind of situation. Or what? You've got to ask the question. He's doing a lot of work here. For somebody who has no opinion, he's doing a lot of work here. So he's been in contact with the legal people from Wabash. He's got surveillance videos. Tilly. He's got somebody to go and photograph inside and outside of that cell. And now he's speaking to the sheriffs from these other counties. I don't know what the dogs are complaining about. Noodle. No idea. The state spoke to Sheriff Troy Hirschberger from Allen County, and he is willing to accept the defendant in his facility, but only at the expense of Carroll County. Okay. Well, shouldn't Carroll County be paying anywhere? He's their person. He's their defendant. So if they were housing him in Carroll County Jail, then it would be the expense of Carroll County. So what's the problem? Is this the heart of the matter? Is this the real issue? That while he's in the Department of Corrections, Carroll County are not footing the bill? Is this all about money? Is this really all about money? And they want him in the Department of Corrections because someone else will foot the bill, not Carroll County. I don't know. It's interesting. That's an interesting sentence. So Allen County will have Richard Allen, but only if Carroll County pays. However, the Allen County Jail is currently overcrowded, and Sheriff Hirschberger would have to make special accommodation to house the defendant. In addition, the Allen County Jail does not have face-to-face visits. All visits are done via video, including attorney visits. Okay, so are they just phasing out in Indiana? Are they phasing out face-to-face visits? Face-to-face visits not a thing anymore. I don't know, but this was Allen County or Adams County. That was what Robert Scremin wanted. So actually now Rosie and Baldwin are back on the team. Rosie would want him in Cass County Jail, who agreed to have him previously, months and months ago. Cass County, which is like down the road from Rosie's office, agreed to have him and said could accommodate him, could look after him, could keep him safe, could accommodate him, and therefore, if he's transferred, Cass County could have him. So this is irrelevant. Slicky Nicky has done work here that he didn't need to do, because we're no longer interested in putting him in Adams County or in Allen County, because those attorneys are gone now. So Slicky Nicky, in posting this, needed to do a little bit more work. He needed to stop poking his nose into a business that, in his own words, he has no opinion of. He needs to just keep out of it. It's not his work to do. Why has he spent time doing this at the good people of Indiana's expense? This is what he's spending his time doing, instead of actually preparing for a trial. He's gone to all of this trouble on an issue that he has no opinion of when there's a trial pending. So get your work done on the trial and actually stop wasting taxpayers' money, Nicholas. Jesus. I'm so mad at this guy. I'm so mad at him. So mad at him. that the defence continues to make unfounded accusations supported by insufficient proof, that the Carroll County Sheriff's Department does not have the manpower to transport the defendant or the room to house the defendant in a manner that ensures his safety. What's that got to do with anything? Then we're not saying that, no one's saying to put him back in Carroll County. No one suggested that. No one suggested that. Rosie suggested Cass County. The old attorneys, Scremin and Labrato, suggested either Allen County or Adams County because those were close to them. No one suggested putting him back in Carroll County. It's irrelevant. Carroll County Jail does not have mental health counsellors or counselling to address any suicidal concerns that have been ongoing. How do you know? Again, something that he's got no opinion of, he's been denied the records of, so why is he going on about it? Once again, for a third time, the colourful, dramatic language used by the defence is an attempt to curry public favour for their client and try this matter in the public eye instead of in the courtroom. So I say again, if Labrato and Scremin hadn't been off the case now, he'd be moving a motion to get them disqualified as well. Because he's calling them colourful, dramatic and inaccurate and lying. All the same things that he accused. He's trying it again. This guy, how tall is he? Because he sounds to me like he's got small dog syndrome. Is he like really small? Like that he has to like bluster and fuss and and, you know, stick his nose in where it doesn't belong and look like he's doing all the work in the world. He's doing all this work when none of that work is his work to do. Unbelievable. It's been a repetitive pattern in this cause. That again, the state has no opinion. He's got no opinion where the defendant should be housed awaiting trial, but the state does take offence to defence once again filing a motion with this court that is full of inaccuracies and allegations not supported by sufficient evidence in order to influence this court to move the defendant. It doesn't matter because you have no opinion. Why are you even here with 8 pages of a document when you have no opinion? The state has no objection to the defendant being moved to a facility within the Department of Corrections, but the court has already addressed that issue in the previous orders. That the defence is consuming the limited resources of this office and this court with repetitive motions that lack any factual basis. How about you spending your time and taxpayers' money when you should be preparing for trial, doing all of this work that is not your work to do? How about that? Right back at you, Nick. Jesus Christ. I can't with this guy. I can't with him. But yeah, that's the end of the document. I can't with this guy. I can't get over the fact he's included a photograph that doesn't do his argument any favours. Doesn't do his argument any favours. You've taken that really close up, so that looks way bigger than it actually is. How about putting a ruler? Go and take this photograph again and put a ruler up to that. Measure it. Because if you're saying that the defence lied and that is a larger hole than 8 inches, just enough space to put a food tray through, that's what they said. Right, well, measure it. Take the photograph again with a ruler up against this door. Bet you won't. Because what you've done is you've taken that so that looks bigger because you've got the background and you think that's huge because look at all those pans and stuff. But that's all about perspective. Look at that chair. It's nearly as big as that chair. What you've done is you've placed that chair far away You've placed it far away. Look how far away that chair is from the actual door to make that hole look bigger. I know what you're doing. I take photographs. I do video. I know what you're doing, you little liar. Thinking that supports your cause, when anybody who has any ounce of common sense realizes that that is a tiny hole. There's no way that you could adequately, based on where that chair is, you could adequately talk to your client in a way that is conducive to any reasonable meeting. And if you're saying that they don't normally do face-to-face meetings, then I don't know what to tell you. The world is just bizarre. The world is bizarre. I can't. Those are two different cells. I think one's from the inside and one's from the outside. So this is the photograph is taken from inside the cell. And then this is outside the cell. So I don't know whether they're two different cells or not. No idea. Can't really tell. Wait, hold on. Yeah, you can't tell. So that's taken from outside. That's taken from inside. Oh, I totally believe you. I totally believe you. It would solve all of their problems if Richard Allen died. It would solve all of their problems. Everything would just go away. It really doesn't. Doesn't help his cause at all. Not at all. They just want him gone. They want the whole thing done and dusted. You know. What can you do? Anyway, that's all the documents that have come out today that I know about, anyway, that I've seen. Just let me check. Just to double check. You never know. You never know what might happen. No, I think that's it. I think that's it. All right, guys. I've been on here for like 2.5 hours. Done a lot of reading. My throat feels really dry, like sucking on a seagull or something. Got feathers in my throat. Yeah, if he dies, the case is done. And little Nicky boy can go home like, pretending that he's a winner when he hasn't actually done anything productive ever in his life. He's such a pretender. He's so sleazy. He's such a, I don't like him at all. For somebody that I've never met, I really don't like that guy. Spitting feathers, yeah. Spitting feathers. Anyway, I'm going to go. This chair doesn't do my back any favours. I need to get myself a new chair. Doesn't do my back any favours whatsoever. All right, guys. Thank you for joining me. Thank you for listening. I'm going to go and catch up with what happened in the Murdoch hearing. I left them at lunchtime, so I'm going to go and catch up on that. We're going to go and see who else has been live about these documents. So I shall see you all tomorrow. Thank you to the mods, as always. Thank you for the donations. Welcome to the new members. And I shall see you in a video tomorrow. Bye, guys.